This is Michael Popok, Legal AF After Dark. Oh, Judge Aileen Cannon, Mar-a-Lago, Florida against Donald Trump. We haven't forgotten about you. We know that you're foot dragging your way through trying to help Donald Trump so he doesn't have a May trial. How many trials can one person be prosecuted under and have to defend themselves at? Well, we're going to find out with Donald Trump. Is it going to be one trial, two trial, three trial, four trials before the November election, or for some reason, no trials? Well, you're going to get updated real fast, only one place, Legal AF on the MeidasTouch Network, the leading podcast at the intersection of law, politics, and justice. Here's a clip from our most recent episode talking about all things Mar-a-Lago.
Popok, finally, I just want to discuss very briefly this issue of, because we're talking about Judge Cannon, so we might as well address the issue anyway. Here's one of the types of things that I think Judge Cannon will eventually, when she has to make an order, which she's avoided doing, she's just issued these paperless minute orders, but she hasn't issued any order that Jack Smith can actually bring an interlocutory appeal on. This specific motion is not necessarily one that I think is like dispositive, but it incorporates a lot of kind of dispositive issues that are right around the horizon there. Jack Smith is saying, look, Donald Trump has claimed before that the reason that one of his things that he said publicly is that he's been relying on his lawyers for this willful retention of national defense information. That's why Trump has these documents at Mar-a-Lago. Well, if you're going to make that argument in court, like you've been trying to make that in part of the kind of PR campaign at your rallies and events and through the media, the case law says you have to disclose that. And the overwhelming case law in the Southern District of Florida, the overwhelming authority and weight of cases is you have to disclose that 60-day, at least sufficiently before the trial, because if you as the defendant are going to blame your lawyer, that's called an advice of counsel defense, that then triggers a burden on you, an affirmative burden that you didn't have as a criminal defendant, a burden of production to now turn over records and documents to prove that you were somehow misled by your lawyer to commit a crime and you relied on the bad advice of your lawyer that vitiates your intent to commit the crime because of what the lawyer told you to do. So it's a waiver of attorney-client privilege. So courts across the country have held you got to disclose that before trial, because if you disclosed it in trial, it creates chaos on the docket. If now all of a sudden mid-trial you say, I'm going with advice of counsel, how do you produce those records in the middle of a trial to the government and satisfy your burden of production without completely disrupting the trial and creating chaos? So Jack Smith filed the motion the same way he did in the DC case, and Judge Chuckin granted Jack Smith's motion, gave Trump a little more time to disclose advice of counsel, though all of those dates are now stayed in the Washington, D.C. District Court. But Jack Smith's requesting the same thing before Judge Aileen Cannon. Trump filed an opposition saying, no, the rules don't apply to me, and just the usual Donald Trump ranting and raving and whining and citing bad case law that isn't relevant. And Jack Smith responded and said, no, you need to, disclose this. I think Judge Cannon will probably rule against Jack Smith there because she always makes the wrong decision. But that combined with Donald Trump will be bringing their motions to dismiss the same way he filed motions to dismiss before Judge Chuckin, which were denied. I think Judge Cannon will grant some of Donald Trump's motions to dismiss on some absurd grounds. That doesn't mean Donald Trump is off the hook. That means Jack Smith can take an appeal to the 11th Circuit, and the 11th Circuit will reverse Judge Cannon. But I tend to think, Popok, that Judge Cannon will grant. I think she's going to make some horrific decisions in the coming few months, which will be a bad headline. But ultimately, for the purposes of Jack Smith, we all know Judge Cannon, I think, is going to do that, even though it's not being talked about now. Jack Smith will have appeals to the 11th Circuit soon. And I think that will stay the same way the DC case has stayed. This is going to stay Judge Cannon's case. So to me, that May 20th, 2024 trial date in the Southern District of Florida isn't going to happen. And given where we are in the DC case, I think the DC criminal case before Judge Chutkin will eventually kind of swoop in right around that time slot. That's my analysis there. Popok, what do you think about that?
I agree with you. I think that the Aileen Cannon case was never going to go forward in May. It was just like when you double book a restaurant thinking you're not going to use the other one. You shouldn't do that, by the way. But I think that's what she was doing. She was like boxing out as best she could to help Donald Trump in any way she could in her scheduling. But I think you're right. There's going to be, I think the Stormy Daniels case goes to trial in New York, especially if there's all these openings that arise because of appeals by Donald Trump and others. I think that the Georgia case against Donald Trump, which we haven't talked much about, but is still there, has not yet been scheduled. I don't think she can cram it in. She certainly can't cram the completion of it in. She's already said she thinks it's an 8 to 9 month, almost a year-long trial against Donald Trump. That's how long it takes in Georgia state process. So even if she started it, it wouldn't finish before the election. If Donald Trump loses, as we all believe he will, then we don't even have to worry about staying or immunity or that type of thing. Her case continues. If he wins, he could try to stop the case in its tracks while at least he was president, not having it dismissed, but having it stopped in his tracks. Supremacy issues haven't even been litigated in Georgia, even though Jack Smith dropped a footnote saying, supremacy related to a state prosecution is for another day. So we'll have to see if that ever gets resolved at that level. So I think you're right. It's no more than 2. I'm just hoping to God it's the Chutkin case and that you and I are not right about the Supreme Court in the briefing process, and that they try to get this. They think it's important from a policy making reason in our in our politics to have Donald Trump tried, not convicted. I want to make it clear. I don't know if he's going to get convicted in a court of law. I have my working theories about that in front of a DC jury with the evidence, just the evidence I know about. I think it would be hard pressed not to be convicted, but just get the trial. That's why the public is a stakeholder in our due process rights and our rights to a fair trial, because it's the public needs to see public trials of people and to have their names either cleared or convicted one way or the other. We'll see if that matters to the United States Supreme Court, or they don't really care about that because they operate on their own timetable and their own ivory tower. They really don't give a crap about our democracy. And we'll have to see again. We'll revisit this issue about what John Roberts is able to pull off. He hasn't been able to pull off things that have mattered to us from a civil rights standpoint or a woman's rights to choose at all. Let's see what he can do on the political front when as Joe Biden, our president, said, there's a dagger placed at the throat of democracy. Let's see if John Roberts has the votes to disarm the person holding the dagger in the form of Donald Trump and do the right thing.
You know, it brings me to the final reflection here of President Biden's speech, where he was just going through a bunch of things that Donald Trump has done and said, like when Donald Trump plays the anthem of the J6 prisoners called the J6 Choir, when Donald Trump mocked that one of his own supporters almost killed Nancy Pelosi's husband, when Donald and then laughed about it and mocked Nancy Pelosi and said she should have built a wall. When Donald Trump talks about being dictator for a day, when Donald Trump talks about terminating the Constitution, and so forth and so on, President Biden said, "Did you ever believe that someone who occupied the White House would say those things? Could you ever believe that someone in the Republican Party who was the leader would ever say those things? Could you ever believe that?" And again, the reason that we're in this constitutional crisis right now is, could you ever believe that anyone seeking the highest office of the land would argue that criminal conduct that they engaged in while previously holding the office, that they are absolutely immune? Could you ever believe that they would argue that that a former president would say they never took an oath to support the United States Constitution? In the legal paperwork, we could all read, or saying that they're not an officer of the United States. The office of presidency is not an office, that the rules don't apply. Could you ever imagine Donald Trump, someone who has that exalted office, citing themselves as evidence in a court case their social media posts. And as we head into 2024, as we're in 2024, it's those kinds of questions that deserve firm answers. And to your point, firm adjudication, firm answers. And are we a nation of laws? Are we a nation of law and order? And I believe that we are. And I think that it's so imperative that we all keep getting out the facts, getting out the data, share Legal AF, show this podcast, show this YouTube channel at MeidasTouch with friends and family and coworkers. Let people know what the facts are and what the data is. I think when people are presented with the data and empowered with truth and facts, they will make the right decision, right, Popok? That's our legal system. When you go in front of a jury, this idea of admissible evidence is so that the jury isn't misled by propaganda and false statements and irrelevant things. But you don't have that when it comes to political campaigns. That doesn't exist where it's admissible evidence. There is a active campaign taking place right now of disinformation out there on both sidesism to prevent the American people from being armed with the true data. And that's all I want to get out there is the true data, the accurate data, the facts.
Well, welcome back. That's exactly what we do, but make it times 5 because we cover at least 4 or 5 stories. We curate for you at the intersection of law, politics, and justice. We only do it in one place, exclusively here. Don't change that channel. We only do it on the MeidasTouch network. Help them get to 2 million free subscribers. They're only 80,000 short. They should be able to cover that like that by the time this hot take is over. If you know all about Legal AF, thank you for being with us. We appreciate you, and we look forward to more success with you, and for you in 2024. Take that clip, send it on to somebody who doesn't know about us. It's a great way to introduce the show. If you have no idea what I'm talking about, that was Legal AF. I am Michael Popok, and this is my hot take to introduce our most recent episode. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.